All right, we're back on the record in the 53rd. We're not. Hang on. We got a technical issue. All right, we're back on the record in 53rd Circuit Court for the County of Sheboygan. Next up, we have People of the State of Michigan versus Gary Tucker, files 20-6034FH. We have Mr. Tucker appearing by Zoom video, as well as his attorney, Mr. Mataloni. Prosecuting attorney, Ms. Goodrich, is in the courtroom. We're providing public access online, as well as in the courtroom, which is open to the public. And Mr. Mataloni, this case is up for a docket call. He's on our jury trial waiting list. Does it remain on the trial docket, or is there any resolution to be had or likely to be had?
There is no resolution at this time, but I am going to be sending out some exhibits that Mr. Tucker is going to be sending me. I don't know if they'll make a difference or not, but for now, it's going to remain on the trial docket.
Okay. Well, we're at the point now where we've resumed jury operations in our trial, so we're in our county, so we're trying to resume, or we're trying to juggle who gets what dates. So I guess, are you, what I don't want to do is set dates that aren't going to go. So are you, I guess, are you at the point where you want us to continue the docket call to see what's going on before we set a firm date, or do you want a firm date and be done with any negotiations?
Maybe another docket call. Like I said, I got some stuff to send out. I don't know if it's going to make a difference, but I certainly don't want to rush to judgment.
Okay. I could give you any objection to that, Ms. Gooder?
No objection.
I could give you either July 27, which would be 2 weeks from now, or August 10th. What would be your preference?
Your Honor, I prefer August 10th because I have a jury trial next week, just to give me time to look over these.
Sure, okay.
Yeah, I was going to say, given the mail and all that, I'm going to have to overnight it just to make sure that it gets there because it's so slow now. I do have it via email. I do have it in text or in an email. I could, I suppose, forward the email if the prosecutor is okay with that. And I'll also mail hard copies, though, so you have them.
Okay, well, what I'll do is I'll continue this then for a docket call on August 10th. Would a morning time work for you, Mr. Mataloni?
Yeah,
10:30.
I right now, the only thing I see is I have a jury trial potentially starting Monday, August 9th. But it's not a case that I expect to take a long time. So I don't know, it may be done in that day. So I don't want to not schedule stuff on the 10th. And
Okay.
This guy's not in jail, and Judge Dragonchuk, we have a lot of people in jail. So his trial might get bumped anyway. So anytime on the 10th works. I'll let the court know if there's going to be a problem by
Sure.
the afternoon of the
If
9th.
you find yourself actually in the trial on the 9th and just have your staff let Ms. Goodrich's office know, I'm sure that we'll either do a stip or something and just move it.
Yeah, and I'll try to talk to the prosecutor before then too, if I think I'm going to be in this trial that way. She can at least let the court know where we stand.
All right, so I'll continue the docket call then to August 10th at 10:30 a.m. and allow Zoom appearances for you and your client.
Thank you.
Any objection to Zoom appearance, Ms. Goodrich?
No.
Okay. All right, we'll see you then.
Okay.
Thank you, sir. Everybody have a good day.
Thank you.
Too. And then we've got Mr. McAfee is scheduled for 1:50. I don't see them yet, so we'll go off record until they're available. All right, the phone that says Galaxy A11, are you Mr. McAfee?
McAfee, yes.
McAfee, sorry, sir. All right. All right, good afternoon, Mr. Jordan.
Good afternoon, Your Honor. Good afternoon, Ms. Goodrich.
Good afternoon.
All right, so we're next up in the case of People of the State of Michigan versus McAfee, file 20-5939FH. We have the defendant present by Zoom video, as well as his attorney, Mr. Jordan. The prosecuting attorney, Ms. Goodrich, is present in the courtroom. We are providing public access not only in the courtroom, but also online. And we're here today for a docket call in this matter. Mr. Jordan is, we have resumed jury trial operations in this county, as most counties in the state have done. So I guess at this point, I'll ask you, is the case either at a point of resolution or likely to head that way, or would you like a firm trial date with no more plea negotiations?
Thank you, Your Honor. Your Honor, I had an opportunity to briefly speak with Ms. Goodrich, and I informed her that Mr. McAfee unfortunately has new charges. He was arraigned on new drug charges, but it would not be a violation of his bond because the charges stem from the search warrant that was executed that give rise to the charges for which he is in front of Your Honor. So basically, he got charged with drugs that were found allegedly in his home in Detroit, and those drugs are also the basis for the conspiracy charges. I say that just to reiterate that he did not violate any conditions of his bond. But Your Honor, because whatever plea he does enter into may have implications with respect to that case, I wanted to confer with the defense attorney on his Detroit case before he entered a plea of guilty. And Ms. Goodrich, I do not think would object to one more adjournment in light of these new developments. That is that he did pick up these new charges. So I can say to the court, I do still think that this case will be resolved, but I did not want to resolve it without speaking to the defense attorney in his new case. May we respectfully, Your Honor, have one more date so that I can talk to her. His next court date in Detroit is August 29th, I believe. But if you give me a date in August, I should be able to have some idea of how this case may impact that case.
Okay. How about August 31st? Would that, is that too close in time to his court date, or?
I do not think that that is too close in time, Your Honor. So I would certainly take that date.
Okay, would,
I mean, if you could give us more time, that would be fine, but the court has been most indulgent, as has Ms. Goodrich. So, and I only say that because if its court date is August 20th, if it's August 30th, then that would just give me one day to find out what happened in that case.
sure. You know, how about I could give you September 7th, just to coordinate. I mean, if there's been new charges filed in Wayne, I mean, they're newly filed, but I know that they're not new conduct.
Yes, Your Honor.
I do want to, I think it's fair to allow you to coordinate that. Ms. Goodrich, do you have any objection to continuing it to the September 7th day?
No, Your Honor.
Mr. Jordan, I could give you September 7th at 1:20 in the afternoon.
Your Honor, that would be most appreciative.
Okay, we'll do that and allow a Zoom appearance. And I know that that's a bit of an unusual length of adjournment as well, but I think that makes the most sense so that Mr. McAfee can, or McAfee, I'm sorry, I keep saying that wrong. Mr. McAfee can, maybe I got it wrong again. Can you remind me how to pronounce your name, sir? I'm going to write that down.
McAfee is like broke down to like three
McAfee. Okay. All right.
Yeah.
I'm going to make a note to myself and try to remember that better, sir. All right. So that Mr. McAfee can coordinate between his attorneys in two different counties. I think it's proper to do that. So we'll continue the docket call to September 7, 1:20 in the afternoon, and allow Zoom appearance.
Thank you, Judge Gauthier. Thank you, Ms. Goodrich.
Okay.
Thank you.
All right. Have a good day, sir. All right. Let's see who this person is. That was Austin Noble. The other one. connected on audio. And we're actually ready for Mr. Sullivan in the Zoom room whenever they want. What's that? You can do Mr. Sullivan in the Zoom room whenever they want. All right, are you Mr. Noble?
Yes, sir.
All right. We've got two cases, People of the State of Michigan versus Austin Noble. Files 21-6106FH and 6118FH. We have Mr. Noble appearing by Zoom video and his attorney, Mr. Gilbert's in the courtroom, as is the prosecuting attorney, Ms. Goodrich. We're providing public access both in the courtroom and online, and is scheduled for a docket call on both matters. Mr. Gilbert?
This is your honor, and the prosecutor and I have discussed this matter, so has Mr. Noble. And we have come to, and I've sent the plea agreement to Mr. Noble. He wishes to accept a plea at this time. He also has his circuit court advice of rights in his possession.
Okay.
If it pleases the court, I have the unsigned copy of the plea. If you'd like me to sign it on his behalf right now, I'd be happy to.
Okay, Mr. Noble, you're aware of the plea agreement in this matter and you wish to enter it?
Yes, Your Honor.
Do you give Mr. Gilbert permission to sign the plea agreement form on your behalf?
Yes, I do.
Okay.
Your Honor, there, I just realized I don't have the updated circuit court case numbers this time.
Oh, that's okay. All right, and Mr. Noble, would you please raise your right hand? Well, actually, put your hand down for a second. I do see the jail arraignment room. We're going to take Mr. Sullivan real quickly and then come back, and because this plea will take a little bit longer. So just sit tight, Mr. Noble. I'll leave you right there for a second.
Okay.
All right, Mr. Sullivan, can you hear us?
Yes, sir.
All right, so we're calling People versus Brian Sullivan, two files, 20-5916 and 5967FH. This case is back in the circuit court after I had granted Mr. Sullivan's post-conviction motion to set aside his pleas. So we're here today for a status conference. We have referred it to the Office of Assigned Counsel, and they have assigned Mr. Gilbert to represent Mr. Sullivan. He's here in the courtroom, as is the prosecuting attorney, Ms. Goodrich. I had also indicated that the prosecutor has until today's date to file an amended information reinstating the charges that had previously been dismissed pursuant to the plea, which has now been withdrawn. And I do have what's entitled a third amended information in both files. So, Mr. Gilbert, have you had a chance to discuss this matter with Mr. Sullivan? Do you have any objections to the filing of the third amended information?
I don't have any objections, Your Honor. I will provide a copy. I actually had met with Mr. Sullivan before I had received those, and I will get a copy to Mr. Sullivan. Mr. Sullivan and I did meet. We'd like this matter go ahead and be set for a docket call and put us back onto a trial footing. Mr. Sullivan had also, on his own accord, submitted a motion to reinstate his bond. I saw that in the paperwork that came back to me. I don't know if the court received that or the prosecutor. If not, I can motion it on for next week.
These two.
Oh, okay. I did not see that.
We did not receive a copy of it.
All right, well, I'll allow you to notice that on.
I will do that.
We'll accept the third amended information for filing in both cases. Would you waive the formal reading or no?
I'll waive the formal reading, Your Honor.
All right. And how does Mr. Sullivan wish to plead to those charges?
He's going to stand mute, Your Honor.
Okay, so I'll enter a plea of not guilty on Mr. Sullivan's behalf in both files as to all charges. And Mr. Sullivan, just, I won't do a formal reading, but I'll just advise you in file 5916, you're charged with delivery of an imitation controlled substance as a second or subsequent offense notice with a habitual offender fourth notice. With the habitual notice, that is a felony crime punishable by up to 15 years in prison and or a $10,000 fine. In file 5967, it's alleged in count 1 that you did deliver the controlled substance heroin as a second offense notice and a habitual offender notice. That is punishable by up to life in prison and or a $25,000 fine and driver's license sanctions. In count 2, it's alleged that you intentionally possessed the controlled substance methamphetamine as a second offense notice and habitual offender. That again is punishable by up to life in prison and or a $15,000 fine and driver's license sanctions. And in count 3, it's alleged that you maintained a dwelling used for keeping or selling of controlled substances as a second offense and habitual offender fourth. That is a felony crime punishable by up to 15 years in prison and or a $25,000 fine and again license sanctions. So I want to advise you of the maximum penalties on those charges. We'll enter a plea of not guilty on your behalf as to all of them. And we'll schedule this then for a docket call. You know, honestly, Mr. Gilbert, the next couple motion days are pretty full, so I'm going to schedule this then for a docket call on August 31st at 2:10 p.m. to be held in person. And I guess since we're setting it that far out, I'll certainly allow you to be heard right now with regard to bond.
Your Honor, we were asking that the court reinstate my client's bond and or reduce it from what it was in the previous file. He has already served, he has gone to prison, he has served 14 months. So any potential plea or that type of thing, a majority of his sentence, I believe he's already served over half of what was factored in on the original, the plea that was then, he was allowed to withdraw. So any potential prison time, he's served almost a substantial amount of that, and it would not behoove him not to run or abscond when he's gotten so much jail time already credited to his case. So we'd ask the court to take that into consideration and impose a bond and or lower than the one that was in the original file. Thank you, Your Honor.
Thank you. Ms. Goodrich, people's response.
Your Honor, Mr. Sullivan has a significant criminal history. It looks like he has 12 prior felonies, 11 prior misdemeanors. There is no offer on the table at this time, and so his potential prison time, he does pour out to a prison grid on the current charges, and ask the court to take that into consideration.
Okay, also certainly his plea having been withdrawn, I think, you know, the statements that he made are not admissible at trial in the case in chief. I understand the law right now, they are admissible as rebuttable evidence. And I mean, he's cloaked with the presumption in terms of the jury, but I don't know in terms of a bond, but I have to disregard the fact that I heard him say under oath what he did, so I know that he's guilty of these crimes. And with the criminal history that he has and the time that he's facing, Mr. Sullivan, you're gonna be held in the jail until we resolve this case. There's just no two ways about it.
Thank you, Your Honor.
Thank you.
All right. All right, so Mr. Noble.
Yes.
All right, so we're recalling your two cases. You want to raise your right hand? Solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, put your hand down. You want to state your name for the record?
Austin Noble.
Hey, Mr. Noble, a guilty plea hearing is an important event. It includes the waiver of constitutional rights you have, so I want you to listen carefully. At any time, if you have questions or doubts or want to talk to your attorney some more, just say so and we can make it happen. Do you understand that?
Yes, I do.
All right, now you're offering to plead guilty to, in file 6106, a charge of entry without breaking with intent. That is a felony crime punishable by up to 5 years in prison and or a $2,500 fine. And in file
216118 FH.
yeah, 6118. You're offering to plead guilty to the charge of conspiracy to commit malicious destruction of personal property of over $1,000, but less than $20,000. That is a
Yes.
felony crime punishable by 5 years in prison and or $10,000 fine. Do you understand the maximum penalty that you could face on those charges?
Yes, I do.
All right. Are you on probation or parole anywhere?
No.
At the time of these offenses, were you on bond for any other case?
No.
Just so the record's clear, I've added the circuit court case numbers to the plea agreement. Do either parties have an objection to that?
No, Your Honor. Thank you.
No objection.
Okay. All right, Mr. Noble, do you understand if I accept your plea, you won't have a trial of any kind and you're giving up your trial rights?
Yep.
All right, how about yes instead of yep?
Yes.
All right. I want to remind you of what some of those most important of those rights are. You have the right to be tried by a jury, to be presumed innocent until proven guilty, and have the prosecutor prove your guilt beyond a reasonable doubt before you can be convicted. Do you understand those rights?
Yes.
You have the right to have witnesses against you appear at that trial. You have the right to question those witnesses. And you have the right to have me order any witness to appear that you wanted to give testimony in your own defense. Do you understand those rights?
Yes.
At the trial, you'd have the right either to remain silent and not have that silence used against you in any way, or you'd have the right to testify in your own defense. Do you understand those rights?
Yes.
And do you understand by pleading guilty, you're giving up all those rights?
Yes.
Is that what you wish to do today?
Yes, sir.
If your plea is accepted, you'll be giving up any claim that it was caused by promises or threats that no one tells me about today. Do you understand that?
Yes.
And you'll also be giving up any claim that it was not your own free choice to enter the plea. Do you understand that?
Yes.
There are also a couple important limits to your appeal rights that I want to make sure you understand. The first is that by pleading guilty, you lose the right to appeal, and you have to, if you want to appeal, get permission by filing an application for leave to appeal. Do you understand that?
Yes.
The second is that you would be waiving some issues entirely. So if you went to trial and were convicted, you could raise any issue you want, but by entering a guilty plea, some issues you can't raise at all. They're waived by a plea. you understand that?
Yes.
That's right. Sorry, I'm trying to do too many things at once and I just lost my train of thought. All right, there's a plea agreement that provides that in exchange for your plea of guilty to the charges I outlined earlier, and there's restitution agreed upon in the amount of $5,294.25 in the entry without breaking file, and $1,950 joint and several with a co-defendant in the MDOP file. In exchange for that, the prosecutor would dismiss counts 2 and 3 in the B&E file. And there's a sentence agreement for HIDA, or Holmes Youthful Trainee Act, where if you complied with everything on probation, it would be a non-public record. You wouldn't have a felony conviction as a result. Do you understand the terms of that plea agreement?
Yes, I do.
And Mr. Gilbert, is that a full, fair, and accurate statement of his terms?
It is, Your Honor. Thank you.
Ms. Goodrich?
Yes, Your Honor.
Mr. Noble, the sentence agreement for youthful trainee status is not binding on me. If I didn't want to give you that at sentencing, I wouldn't have to. But you would be allowed to withdraw your plea if I don't give you that. Do you understand that?
Yes.
There's a very important exception to that rule that I want to make sure you understand and agree to. If you engage in misconduct between now and the time of the date of sentencing, by not appearing for court or absconding your bond, committing more crimes, or violating a condition of your bond, by your misconduct, you would be forfeiting the right to withdraw that plea, even if I don't give you the Youthful Trainee Act. Do you understand that?
Yes, I do.
All right. Other than the terms of the plea agreement, has anybody promised you anything to get you to plead guilty?
No.
Has anybody threatened you to get you to plead?
No.
Is it your own free choice to plead guilty?
Yes, it is.
Knowing all this, how do you wish to plead the charge of entry without breaking with intent?
Guilty.
How do you wish to plead to the charge of conspiracy to commit malicious destruction of personal property over $1,000?
Guilty.
Mr. Gilbert?
Thank you, Your Honor. Hey, Mr. Noble, we're going to go one file at a time, okay?
Okay.
In November of 2010, right around the 22nd day, can you tell me what happened where you destroyed or harmed someone's property?
What date was that?
That would have been in November of 2020.
Okay. The windows you're talking about?
Yes.
Okay, what was your question again? I'm sorry.
Okay, what did you do to destroy or damage windows on that day?
Well, me and my buddy were drinking and we were being stupid and decided to go, or we were just walking around and he decided was like, hey, let's go break these windows. So me and him were gonna go grab rocks and put them through the window.
Okay, and where were these windows located?
By the walk bridge.
Okay, and that was in the city of Sheboygan?
Yes, sir.
And those were the windows on the walk bridge?
Yes.
Okay, and was there more than one?
No, there was,
Okay.
I think 3 or 4.
Okay, so more than one window you broke.
Yes.
And you would agree that the total value of those windows that you broke on the walk bridge exceeded $1,000?
I believe so.
Okay. And again, that happened here in Sheboygan, the city of Sheboygan, Sheboygan County. And in addition, you were working, it was you and another individual that threw the rocks through those windows, correct?
Yes.
Okay. Now I'm going to take you to another date, and that would be in February, March of 2020. At some point in time, did you enter a building without permission?
Yes.
And when you entered that, where was that building located?
In Sheboygan County.
Okay, about where in Sheboygan County?
By the tissue factory.
Okay, and you entered that building with the intent to steal something?
Yes.
Okay, and you weren't the owner of that building, is that correct?
Sorry, what?
You were not the owner of that building, were you?
No.
And you didn't have permission to go into that building?
No, sir.
Okay, I have no further questions, Your Honor, thank you.
You believe the factual basis is established, Mr. Gilbert?
I do, Your Honor,
Ms.
thanks.
Goodrich?
Yes.
And Mr. Gilbert, are you aware of any other promises, threats, or inducements?
I am not.
Ms. Goodrich?
No, Your Honor.
And Mr. Gilbert, in your judgment, has the court fully complied with the requirements of MCR 6.302?
The court has, thank you.
Ms. Goodrich?
Yes, Your Honor.
Mr. Noble, we've given you a lot of information. It's possible that may have caused you to change your mind, so I ask you once more, how do you wish to plead to the charges of entry without breaking with intent and malicious destruction of personal property?
Guilty.
Well, I find that your pleas are knowingly, understandingly, and voluntarily made, and that there's a sufficient basis in fact and law to believe you're guilty of those crimes. So I do hereby accept your pleas of guilty. And we'll schedule sentencing for August 31st at 2:30 in the afternoon in person here in the courtroom. And you're going to have to meet with the probation officer to interview you and prepare an investigation report for me so I know a little bit more about you and what's going on with you, okay?
Yes, sir.
All right, and any objection to continuing bond, Ms. Goodrich?
No objection.
Okay, we'll continue bond. We'll see you on August 31st, okay?
Yes, sir. Have a good day.
Okay, you too. All right, and we also have on the docket a status conference for People versus Charlie Rolfe. It's two files, 21-6090 and 6095 FH. Last I knew, we were awaiting the results of an evaluation from the Center for Forensic Psychiatry. Mr. Gilbert, do you have any additional information?
I do not, we're still waiting, Your Honor.
Looks like the video conference was done on June 10th, and then they're waiting for additional information and Monday morning.
Okay. Do you know if they've received the additional information they needed?
The last letter I have is dated June 10th.
Okay. All right, well, and this was for not only criminal responsibility, but competency, right? So we're on hold. Okay. Well, what I'll do is I'll schedule this for a continued status conference on the August date. Obviously, if we get the result beforehand by statute, we got to come in on competency hearing within 3 or 5 days anyway. So I'll set it for August 31st at 2:40 in the afternoon. For a status conference. And allow that to be by Zoom for Mr. Rawl. Looks like now our next case is Mr. Coonrod or Ms. Panicali. Neither are in the waiting room just yet, so we can go off the record until they're ready.
Thank you, Your Honor.
All right, we're continuing our docket with People of the State of Michigan versus Zachary Coonrod, file 20-6040FH. We have Mr. Coonrod with us by Zoom video. His attorney, Mr. Gilbert, is with us in the courtroom, as is the prosecuting attorney, Ms. Goodrich. This time and date set for a docket call in this matter. Mr. Gilbert.
Your Honor, I have spoken with the prosecutor and I've also spoken with my client. This case is fairly complex with the amount of documentation and paperwork. We'd ask the court to give us another docket call if it pleases the court. So we're in the process of working through all the evidence that was provided through discovery and trying to organize it and spreadsheet it and that type of thing. So additional time might help us to resolve this.
Okay, Ms. Goodrich, any objection to a continuance?
No objection.
All right, well, due to the nature of the charges, those involve usually complex financial records to review as well. So I'll continue this then to August 31st at 2:20 p.m. And we'll schedule that to be in person. Anything further, Mr. Gilbert?
No, Your Honor, thank you.
Ms. Goodrich?
Nothing further, thank you.
Okay, we'll see you at the end of August, Mr. Coonrod. All right, next we have, Anna Colley is scheduled at 2:50. We're a little bit ahead of schedule, so we can take a recess until that case is ready.